This I had read yesterday fully. And yesterday, my lord, I mentioned the object of this law is in fact to strengthen the law of corruption, but also make sure at the same time it is not abused. And please see page 3 of, at the foot of the page, there is a small page in page 3 of 99. So this is also a reflection of the Honorable Prime Minister's commitment towards zero tolerance. You would recall that.
Oh, which document?
I'm so sorry. Parliamentary debate. The first part deals with the new offences which have been created. At the foot of page 3, similarly, the minister introducing, before proceeding against any officer, prior permission which was earlier available only at the level of joint secretary and above is now available at all levels. The permission has to be obtained within 3 months. This was what I had actually. In fact, Your Lordship may see a. First, he says 2 main aspects have been taken of making corruption law more stringent, active bribery, and at the same time ensuring enough safeguards for those public servants and officers for performing their duty with honesty so that unwarranted intimidation does not kill the initiative. So we have introduced the bill, the provision of a timeline for prosecution, etc. What is this? The members' speech. Then, Malad, I mean, this is of limited assistance, only to show that this is the single line directive which has now been legislated. Malad, I just need to deal now quickly with the cases. Yashwant's case, Your Lordship had seen.
Just 1 minute.
Paragraphs.
You are discharging the board now. Sir.
Till lunch we discharge.
Till lunch. Then we'll take the regular list. Yes.
My Lord, Yashwant's judgment, quickly, Your Lordship, just to remind Lordship of the passages I cited, 2020, volume 2, SCC 33A. You give this compilation? The compilation, I believe, was handed over.
Yes.
Which compilation? There are so many of them.
It says judgment index at the top.
I believe it says judgment index.
We found it.
Your Lordship said.
Yes, we have.
This page 50, yes, Mr. Justice Joseph's judgment. It's printed page 390, in this compilation it's page 54. In fact, last line in para 53.
No, compilation page 54.
53 actually, if Your Lordship can just pick it up from 53.
So the dates of this. Dates it, so.
And at page 53, Your Lordship, the petitioners have not sought the relief of a preliminary inquiry being conducted. Even assuming that a smaller relief than the one sought could be granted. But the argument was, if I ask for an investigation, you can always direct preliminary inquiry. There is yet another seemingly insuperable obstacle. In the year 2018, the Prevention of Corruption Act here referred to was brought into force. Thereafter, 17A new section was inserted. Then para 117. In terms of 17A, no police officer is permitted to conduct any inquiry or conduct any investigation into any offence done by the public servant, where the offence alleged is relatable to any recommendation made by the public servant in discharge of his public functions without previous approval inter alia of the authority competent to remove the public servant from his office at the time when the offence was alleged to have been committed. In respect of the public servant who is involved in the case, it is clause C which is applicable. Unless, therefore, there is previous approval, there could be neither inquiry nor investigation. It is in this context apposite to notice that the complaint that has been filed by the petitioner in writ petition was moved by the respondent. CBI is done after 17A was inserted. The complaint is 4th October. Para 5 sets out the relief which is sought in the complaint is to register FIR under various provisions. 6 and 7 of the complaint are relevant in the context of 17A, which reads follows, which says, we are aware recently 17A has been brought by way of an amendment to introduce requirement of prior permission of the government for investigation under the prevention. We are also aware that this will place you in the peculiar situation of having to ask the accused himself for permission to investigate a case. We realize your hands are tied. We request you to at least take the first step of seeking the permission of the government under 17A for investigating, under which the concerned authority shall convey within 3 months, which may, for reasons to be recorded in writing, be extended for 1. Therefore, the petitioners have filed the complaint fully knowing that 17A constitutes a bar to any inquiry or investigation, unless there was previous approval. In fact, a request was made to take at least the first step of the permission under 17A. The writ petition was filed on 24th October, and the complaint is based on non-registration. There is no challenge to 17A. Under the law, it's both on the date of filing the petition and even today. 17A continues to be on the statute book and constitutes a bar to any inquiry or investigation. The petitioner themselves in their complaint request, or when it comes to the relief, there was no relief claim. Even proceeding to the complaint, an FIR must be registered as it purports to disclose cognizable offences, and the court must so direct. Will it not be a futile exercise having regard to 17A? In fact, the High Court judgment, which says constitutional court's powers are not impaired, doesn't seem to be correct in the light of this. And therefore, the view that although otherwise petitioners so and so may have made out a case having regard to law, actually they are done in the and more importantly, 17A in a review petition, petitioner cannot succeed. However, it is my view that the judgment sought to be reviewed would not stand in the way of the first respondent from taking action on the complaint in accordance with law, subject to the respondent obtaining under 17A of the Act. Now, the offence is, my lord, here. Your Lordship recall that I had shown page 23, relate to 2016. First A was to constitute a special investigating team under the supervision of the court with the following mandate: 1, 2, 3, 4, 5, and then, my lord, B, to terminate/cancel the intergovernmental agreement with the government of French Republic signed on 23rd September 16 for the purchase of 36 Rafale fighter jets, and to give direction to the respondent to lodge an FIR and report the progress of investigation, and to restore the earlier deal for the purchase of 126 Rafale fighters, which was cancelled on June 15 by the government of India, to Bard, Dassault, Reliance Aerospace, etc., etc. These were all events of 2016. And this, in my respectful submission, authoritatively lays down the law. Now, Tejmal's judgment, my lord, doesn't strike a different tone as is sought to be conveyed. It's in this very paper book, my lord, page 55, page 56. Para 4 of the judgment says that the FIR has been quashed mainly on the ground the investigating authorities failed to obtain previous approval of the government under 17A before registering. Then 17A is set out. Then please see para 6. So that argument was on a wrong factual premise. In this case, FIR was filed on 1st January 2018 before the provision came into force. Main question involved in the appeals is whether 17A would apply to an investigation which commenced before 17A was enacted or enforced. But this, in my respectful submission, that would make it really retrospective. If it stops an ongoing investigation in its tracks. It's a cardinal principle of construction. Every statute is prospective unless it is expressly by necessary implication made to have retrospective effect, my lord. This proposition, in fact, it appears that counsel argued that this is the correct position. The other line of cases was not shown to the case court. There is a presumption against retrospective provision should ordinarily be made to make a statute retrospective. Presumption may also be rebutted as held in Akram Ansari, which has been referred to and relied upon in the judgment in K.R. Ramesh. The device of a legal fiction can be